I'm here with Jamie Robinson from K&L Gates in Brisbane. Jamie very kindly spoke at our conference on the Gold Coast last week on the subject of the industrial relations reforms. He was talking to a group of agricultural business general counsel, but these comments are relevant, I think, to all of us who are interested in the changes in employment law. Jamie, thank you so much for joining us. What are the key changes you think are going to have the most impact on employers?
Robert, thank you. And obviously, thank you for the invite to speak to your Agribusiness Conference last week. It was very enjoyable indeed. And from my perspective, a whole variety of changes, which are obviously coming in the employment space across casual employees, contractors, labour hire, same job, same pay, changes to restrictions in maximum term contract usage. But the one that's probably, from my perspective, to the fore and hasn't been spoken about a lot is changes to the flexible working arrangements regime. And the reason I raise that is because, look, obviously lots of employees are increasingly seeking flexible working arrangements. There's been an expansion of the criteria upon which they can seek those arrangements away from just having children, having to care for other members of the family, and also for elderly parents, amongst others, to include employees who are pregnant, but also those that are suffering or need to care for somebody who is in a domestic violence situation. But from my perspective, the real key part of the changes here is the change to the regime and the change in onus on employers for how they deal with those arrangements. The first thing that employers really need to recognise in relation to the changes is that there is going to now be an ability for employees to approach the Fair Work Commission if they think a flexible working arrangement has been unfairly declined by an employer. Historically, there was very little opportunity for an employee to challenge an employer declining a flexible working arrangement. There's also a process now whereby the employer has to respond to the flexible working arrangement request within 21 days. The response has to be in writing, and before the response is made, the employer must have discussed the request with the employee, must genuinely have tried to reach agreement with the employee about making the changes that the employee is seeking. And if the arrangement can't be agreed, the employer needs to explain in writing to the employee why the request is being refused on reasonable business grounds. As I've indicated, that needs to be detailed in writing, and obviously that then forms the platform for the employee to potentially challenge it in the Fair Work Commission on the basis that the employer has not allowed the request on the basis that the grounds are unreasonable. So there is now an ability to challenge, and employers must bear that in mind when they're considering what it is that they're going to allow or refuse in terms of flexible working arrangements. So that, to me, is one of the primary changes moving forward.
That's a very interesting point you make. It sounds as though it's a bit of a process, almost like unfair dismissal. When you're dismissing someone, you've got to go through a process. When someone makes an application for flexible work, you've got to go through a process. If you don't, you're in the FWC, at least theoretically.
That's correct, Robert, absolutely. And the process is going to be fundamentally important to whether you're going to be potentially overturned by the Commission or not. And the Commission, as a last resort, does have an ability to arbitrate these requests.
Jamie, thank you very much. Fascinating stuff. We'll watch this space with interest.
Thanks, Robert.